All right, here we go. So, on behalf of WWF, World Youth for Climate Justice, German Watch, Global Focus, and Can Europe, I'm very happy to welcome you to this webinar on the International Court of Justice Advisory Opinion on Climate Change. So my name is Romain, and I work at Can Europe as a Climate Governance and Human Rights Policy Coordinator. And the objective of today's webinar is to offer a reading of this advisory opinion directed at European NGOs in the context of the upcoming COP at Belém, but also beyond. And the idea is really to try to assess how the advisory opinion can actually help the advocacy of European NGOs and can have real consequences in the policy world as soon as possible. So some housekeeping rules, maybe. So we would be grateful if you could indicate in your name tag not only your name, but also the organization you work for. As you will see, we will start with some presentations on several aspects of the advisory opinion. If you have any burning question during those presentations, I would invite you to paste those questions in the chat, and then we will try to answer straight away. But then, as you will see, we will also have a more interactive space towards the end of the webinar, and we would love to hear from you. So in case you have longer reflections, please keep those longer reflections for this second part of the webinar, which will be more interactive. So I will start by presenting the agenda. And we will first have two presentations on the journey that led to the adoption of this advisory opinion and also its legal significance. This will be presented by Henrike Bunger and Nicole Pons from World Youth for Climate Justice. Then we will dive a little bit deeper into some of the issues that are covered in the advisory opinion. And here we will have Shirley Matheson from WWF International, but also Sofia Kessi from WWF European Policy Office. And we will also have as a speaker Masha Klein from German Watch and myself. During the last part of the webinar, we will say a few words about what are the next steps for the advisor opinion, explaining that it is actually not the end of the road now that we have it. And then we will turn to this more interactive exchange, as I was just saying. And this will be introduced by Sigrid Pierre Anderson from Global Focus. So I hope this agenda sounds good to everyone. And I would now hand the floor over to Henrike to kick us off.
Yes, thank you, Roma, and also welcome to everyone from my side. I would briefly like to give a bit of a background, as previously stated, on the background of the advisory opinion and how it all came to be. Most importantly here to know, I think, is that this has been a very successful youth-led endeavor from the get-go. So it originated in the Pacific Islands as 27 law students has been challenged by the professor to think about how they could legally advance their rights in light of the climate crisis that has been an ongoing reality for them already back then. So this has been an endeavor ongoing since 2019 and has since been spearheaded by Vanuatu, who has agreed to take this forward to make or to rally other states to support this endeavor and request an advisory opinion from the International Court of Justice. And World Youth for Climate Justice was a global youth organization founded to sort of rally youth from all over the world to support this and gather the state support to vote in favor of this resolution. So I think in this regard, it's also really important to highlight the support of NGOs throughout the journey and the importance of civil society alliance and making this a successful request to the United Nations General Assembly. So I'm really, really happy to see many of you here today to see how we can continue then this civil society alliance going forward. A little bit also about sort of the timeline that we've been looking at. So the United Nations General Assembly vote was successfully passed by consensus in March 2023. So 4 years after this idea was first born in the classroom at the University of the South Pacific. And since we have seen the written submissions by states throughout 2024, accumulating in the oral hearings, which took place in December 2024. And lastly, followed by the delivery of the advisory opinion, finally this year in July. So it has been a long, long journey that brought us all here today, and we're very, very happy that this has finally, yeah, come to life. So what we've seen throughout, as I said before, there was broad youth participation and also civil society engagement on this to engage with states on their positions that have been submitted to the court. And this could, both in terms of overarching themes and lines of argumentation that we would like to see, but we've also noticed that there have been already throughout the oral proceedings and the written statements also some hesitation from certain countries. So I think this is really good to keep in mind when analyzing the background and also defining strategies going forward. But first and foremost, let's dive a bit more into understanding the scope of the court and also the advisory opinion itself. So who is generally bound by the obligations that have been clarified by the International Court of Justice. Generally, the obligations that have been set out as part of specific treaties, obviously, are mostly binding to the parties to those treaties. So under the Paris Agreement, the parties that are, that have signed and ratified it. But the court also very clearly clarified that some of the obligations stemming from the advisory opinion are of a customary international law nature or are customary obligations and general principles, some of which even have erga omnes character. So the ICJ here very clearly stated that the obligations towards climate change that it has clarified also very much apply to all states a part of the international community. So I think this is a very specific, important emphasis to make here. And what we've seen so far as well is that the question often comes up of whether the advisory opinion is actually binding. And while we obviously, as the name suggests, see that it is an advice that has been requested by states from the court, so it's like of an advisory character, it does have, in fact, binding legislation that underlies the interpretation of this court. So the idea that it is non-binding as such is now being used, especially by high polluting states, in order to continue escaping their liability and to weaken the court's pronouncements. So governments have sort of been avoiding the notion of a legally binding effect. But the fact is that the court has not only an authoritative function in overseeing the corpus of law, but also that, as I mentioned before, the legislation that underlies the obligations that the court has interpreted is binding. And this is something that states have agreed to. So for example, the Paris Agreement has set out obligations whose nature has been further concretized by the court, but it's not adding any new obligations. It is merely interpreting what states have already agreed to be bound to. So states are not free to not follow the law, as it's ascertained in this advisory opinion. And yeah, calling the advisory opinion non-binding is, may create the false illusion that the obligations that it clarified then are not. But what we saw is that it was the broadest state participation historically as well. So the simple engagement also with the law and the engagement by specific states and their submissions to the court show that they not only respect the proceedings, but also can obviously afterwards not say, okay, we're rejecting the ruling because it simply does not state what we would like it to. So if we could go to the next slide, we can briefly look at what has happened since. Thank you. Well, as I said, the AO has attracted very high participation. It was above 90 written statements, 110 oral statements roughly, and European participation within was substantial. But what we also saw was that there was some significant divergence within European states' opinions. So we saw that some of the Western and Nordic European states argued throughout, I want to say for more robust state obligations, linking climate change also to human rights, so creating this nexus there, and also arguing in favor of due diligence and possible legal consequences for the failure to act, while some other states, especially those that were a bit cautious about the potential implications of an advisory opinion, pressed for also a bit more of a narrow reading. On this, I would also highly recommend to read the daily debriefs that WICJ has published, summarizing also some of the written statements and the oral statements made, if anyone would like to read upon specific countries' stance in this regard that has been presented throughout. So what I can say is that throughout, there's already been a bit of a pushback, specifically on like the limited legal binding obligations stemming from the Paris Agreement, rejection of the common but differentiated responsibilities principle, obviously also rejection of responsibility for historic emissions and so on. So since then, since the big moment in July, we've seen some governments come out with statements. So there has been broad media attention generally on the proceedings. And I want to say some countries were also more supportive of what has been said by the court. For example, what we saw, I think Malta has reaffirmed the historic moment that it has been, and many other countries have also come out in favor. But what I'd specifically like to highlight is here maybe also which countries have not been super progressive in welcoming this advisory opinion. For example, we saw from Germany broad emphasis on this non-legally binding character of the advisory opinion. And there was also some significant pushback from Germany and France on the European NDC, even though that clearly contradicts what the court has clarified. Furthermore, also Switzerland, for example, has been hesitant to reaffirm the ICJAO. I think also in light of the ongoing Klimaseniorinnen implementation problematic that they're facing. So concerns have been raised about sort of implications on the practical governance issues of the obligations clarified. As to the EU's position, there have been parliamentary questions posed to the Commission to react to the advisory opinion and to see how the European Union will pursue further action in this regard. This is also something that World Youth for Climate Justice has been actively engaging with, so posing parliamentary questions to national governments to take a stand on how they perceive the advisory opinion. And what we also see is that many countries have already inquired upon how to best utilize the ICJAO or what to look out for in their COP30 advocacy. So I'm really happy that we're creating this space here today to also talk about this further. But last but not least, I also wanted to highlight that there have been already some case law developments in utilizing the ICJAO for arguing a strong climate base or arguing for strong climate obligations. For example, the case against the a major emitter in Switzerland, where the plaintiffs also referenced the advisory opinion. When this can be seen all over the world, but I think something particularly to look out for in Europe. So this so much is a very quick and brief rundown on what has been happening so far, and maybe a little snippet insight into where we are right now. And with that, I would like to hand it over to Nicole to talk further about the legal significance of the advisory opinion going forward. Thank you.
Yeah, thank you very much, Henry, for that brilliant overview and explanation of where we are so far. My task here today is to give a brief rundown of the legal significance of the ICJAO, and our lineup of brilliant speakers will elaborate on that later on. I guess for the first part, I'd just like to highlight this phrase by the ICJ when it said that the questions put to it by the General Assembly represent more than a legal problem. They concern an existential problem of planetary proportion. And I'd just like to highlight that because I think this right here is a testament to the impressive effort of civil society organizations and frontline advocates who made sure that people on the front lines are heard in this process. And I'd like to highlight how really the people were not separate from this process. It was not the ICJ and then outside we have the people, but we were actually, and many of us were actually involved in this process, which is really quite unprecedented. And that's why, for me, this is a historical not just a legal breakthrough, but a moral one. And the court clarified that when it also explained the authoritative interpretation of international law, when it explained that the treaty and customary rules mutually inform each other, and that the climate change treaties do not exclude the application of other laws of international law. So the UN Framework Convention on Climate Change, for example, the Kyoto Protocol and the Paris Agreement are complementary, and that the UNFCCC sets objectives and principles while the others translate this into concrete obligations. So for COP with Henry here, our goal is really to reinforce that international law applies in negotiation rooms, and that also it established binding duties of prevention and due diligence, that customary international laws, duty to prevent transboundary environmental harm is fully applicable with respect to the climate system, because climate change poses a scientifically demonstrated indisputable risk to all states, and this obligation must be performed under a stringent due diligence standard. And also, it highlighted the recognition of human rights and intergenerational equity. It reiterated that the environment is the foundation for human life, upon which the health and well-being of both present and future generations depend. And it also highlighted that the protection of the environment is a precondition for the enjoyment of human rights. And next slide, please. So another legal significance of the AO is that on highlighting the accountability for fossil fuels and private actors. So for the first time, the ICJ directly addressed fossil fuel production and subsidies, declaring that failing to phase them out may violate international law. And this will be elaborated further later on. Also, it discussed the protection of statehood and non-refoulement. It clarified that a sea level rise does not negate a state's legal personality or maritime boundaries, and that preserving the rights of small island nations. It gave a strong presumption in favor of continued statehood, and that it should apply. So the application again of the customary international law of principle of non-refoulement applies. And then lastly, it clarified the consequences of violating legal obligations. So we're talking here about cessation, non-repetition, reparation, and compensation, and that any breach of legal obligations by a state in the climate context triggers the full suit of legal consequences under the international law of state responsibility. Therefore, the responsible state must continue fulfilling its obligations despite the breach, for example, by adopting revised mitigation measures or enhancing carbon sinks. And where damage materializes, the state must make full reparation through restitution, compensation, and satisfaction. And with that, I'll end my presentation. I'll hand it over to Masha, I believe, or Shirley.
Yes. Thanks a lot, Henry and Nicole. I think this was a very helpful introduction to DAO. We will now dive a little deeper into some of the thematic issues that have been addressed by the advisory opinion, and we'll start by talking about the nationally determined contributions and the 1.5 degree obligation. And I would invite Shirley Matheson from WWF International to take the floor.
Thanks, Roman. So hi, everybody. So I'm from WWF. I'm actually on the policy side, and my focus is on nationally determined contributions. So this is just a bit of a reflection on my side on how things landed here. I'm assuming that everybody is up to date on this, but just as a quick overview, what we're talking about are national climate plans, which countries are already obligated to submit to the UNFCCC as part of the agreement under the Paris Agreement. So this is part of the ambition cycle. It's interesting, first of all, to just note that nationally determined contributions came out in the advisory opinion. And certainly if you followed the announcement and when it was being presented from the ICJ, I myself was quite surprised about, the language and how much of a focus was on the NDCs, which was great to really see. One of the reasons for this is perhaps that this is a really important year for NDCs. This is a really important milestone. Governments are being asked to submit NDCs 3.0, which will be responding to the first global stocktake. And certainly the NDC synthesis report was published earlier today. But also that NDCs are the fundamental instrument under the Paris Agreement, where those who are part of the Paris Agreement can really show that they are, meeting these obligations. And indeed, that's something that they did emphasize in the advisory opinion. What I've done here is on the left side of the slide, I've taken some of the text and highlighted some elements, and on the right sort of pulled out some of the key points. But as you see, I've highlighted the 1.5 degrees Celsius. And here, this is just to show that certainly the Paris Agreement has always been, originally it was to pursue actions which will keep us below 2 degrees. And this has evolved over time, including since we've had the periodic review to really include a 1.5 as a really important element. So pursuing, less than 2 degrees and as much as possible towards 1.5. What the advisory opinion did was really say from a legal perspective, the obligation is really focused around 1.5. And that's a really helpful direction. I think it really sort of solidifies a lot of what we have been saying, but some countries have sort of been sidelining in some ways. So that was a really helpful declaration from the advisory opinion's perspective. Other elements which are really important in here is that, NDCs must move towards 1.5. They must have highest possible ambition in them. So they must show good faith and really be putting in the highest possible ambition. One of the challenges we sometimes have with nationally determined contributions is this nationally determined aspect of it. And countries will say, well, it's our choice to put in what we want. We decide what good is. And what the advisory opinion says is you don't have full discretion on deciding yourself on what highest possible ambition is and what is helpful. There is elements which will support you with this, such as the global stocktake, such as best available science, and then also think about, how these elements play out. So Sophia and I were discussing this before, and I was saying Europe is quite an interesting case because there is a scientific board, and other countries have that as well, which provide pathways to 1.5, which really can be seen as an interesting benchmark for courts to look at if that becomes the discussion point. Progression over time is really important as well. This again says there's a legal obligation for countries not to backtrack on what they've done. So to put in ambition now and then revise it later to make it less ambitious, that isn't really acting in good faith. And they really sort of put that out there. I think that's a very interesting development of some of the cases that we've seen so far, which I'll talk about in a second. And then one thing I think is really important to talk about is that in terms of obligation, it's not solely aspirational. So countries can't just say, this is our ambition, and so we've done enough. There is an element that parties and countries need to show that they are taking all available steps to meet those targets. But the other thing to note, it is an obligation of results. So they have to show that they are taking all activities which would lead to that outcome. But if they don't get that outcome, that's not something that they can be taken to court on. I think the court recognizes that there's lots of dynamics there. So just to note that kind of element within there. So in terms of, so that's a little bit on the obligations. If we look at the consequences of breach, I think this is more of a very interesting point to just think yourself, like with all of this context, if we look at how countries are doing on NDCs, what could be a consequence of breach, and how could we sort of say, well, this is not meeting the obligation, so this is what we want. I wanted to point to a few cases that have already happened, which show a good precedent on how this has kind of been a movement over the years. There's one in France that was in 2021, where the administration was taken to court for failing to meet their climate targets. and the state was found liable for what they called climate inaction. And the consequence of this is that they had to repair the ecological damage that they'd done by the activities which were considered in breach there. So that's a good kind of example of reparation, which has already kind of come through the courts. There's also a series of cases in Brazil, very interesting, taken up against the government, which was Bolsonaro's government at the time, to say, that you're failing to do what you're obligated to do in terms of climate there. And one I thought was particularly interesting was an argument that the government is really paralyzing the Amazon Fund, which finances anti-deforestation projects, so that by doing that, they're not fulfilling their obligations. And this is something that the courts upheld and ordered the government to reactivate the fund. So again, that's ceasing what they were doing, which is bad, and doing what they really should be doing, so reactivating the fund there. And lastly, Mexico, I think, is a very interesting one. The Mexican government was accused of submitting the NDC in the last round, which was less ambitious than its previous one. So like I say, it breached this obligation of progression over time, and the courts did uphold this challenge. So they did find that, and they did say that that is in breach of what was expected of them. And so they had to they were asked to go and revisit their NDC. Yeah, so I think like a few examples of how this has been building even before the advisory opinion, but some examples of what we can expect to come out if and when this comes forward. Before I finish, just to talk a little bit, the NDCs are very important for COP30, which I'm off to on Sunday, so it's a very busy time for us. But to say that it would be interesting to see how this lands there, because NDC 3.0 is going to be a big talking point and probably underline a lot of the discussions there, even though it's not on the formal agenda. WWF is going there with some analysis which could be helpful in understanding to what extent countries are fulfilling this obligation. And I'm sure others are. Like I said, we've had the NDC synthesis report come out, which has given some really positive messages, but we're still waiting for some key players like the EU and China. So very important to think about this. And we are also wondering if FINATA will be coming with a draft of the UN resolution. So that will be another talking point. So something to look out for. I don't think we will see it very front and center on the formal negotiations. I'm happy to be corrected on that. That would be wonderful. But I think we should see a lot of discussions around this in the informal space, and that's something that we're also kind of be sort of facilitating as well on our side. So I'll stop there on NDCs. And who do I hand over to next, Roman?
Thanks a lot, Shirley. I think it was extremely instructive and interesting. It's now Masha's turn to take the floor to walk us through the fossil fuels and private sector regulation and also international climate finance aspects. So Masha, you have the floor.
Thank you so much. I think, yeah, this is a really important aspect because, as you all know, companies are major contributors to the climate crisis. And we see just around 57 companies that can be linked to 80% of GHG emissions since 2016. So they play a huge role when it comes to mitigation, but also for climate finance because they have the financial resources. So before I talk about what the ICJAO does say, I want to talk about what the ICJAO doesn't say. So in terms of what they don't say, it doesn't state that companies themselves have obligations with respect to climate change or human rights. The ICJAO doesn't specify what potential obligations may be because they don't define these, and thus they don't speak about monitoring or consequences of duty breaches. They don't speak about the question of access to information, which is a huge issue when it comes to corporations, transparency, or going up against problems like greenwashing, undue political influence, and even the issue of private capital, which is quite important, as I mentioned, when it comes to climate finance. If you're wondering who actually said all of this, it's the Inter-American Court of Human Rights, who really went into these obligations of corporations. And you can tell that it's, yeah, quite ambitious, and you'll probably guess that the ICJAO is less ambitious in that respect. For instance, also when we look into the polluter pays principle, the Inter-American Court of Human Rights says corporate responsibility has to be aimed at putting the polluter pays principle into practice, whereas the ICJAO explicitly states that the polluter pays principle is not reflected in climate treaties. It doesn't consider it part of the applicable law for the purposes of the AO. Nonetheless, the ICJAO does contain some very important aspects on the role of the private sector. And therefore, yeah, I want to go into what the ICJ actually did say. So the AO only addresses states' obligations, and states have the obligation to pursue domestic mitigation measures. We could also move to the next slide, I think. And what that means is that regulating private entities can become necessary when they are the ones causing the emissions. So what would a breach of obligation be? The ICJ clarifies that GHG emissions of private entities cannot be directly attributed to a state, but it could constitute an internationally wrongful act if a state fails to regulate a private entity. And the ICJ here explicitly says that could mean not taking the necessary regulatory and legislative measures to limit the quantity of emissions caused by private actors under its jurisdiction. The ICJAO also explicitly names activities linked to an internationally wrongful act, like fossil fuel production, consumption, licensing, subsidies, all of which are activities that are also oftentimes conducted by private entities. And I think for corporate climate litigation, the ICJAO also offers a lot of material. It's great to see that the court is clear that, for instance, even though the climate crisis is complex, it's not too complex to establish causation, attributability, which also echoes what a German domestic court has said this year in the case of Yuya versus RWE, that in principle, legally, causation can be established between entities that emit and climate damages, climate risks. The ICJAO also explicitly says that as part of the EIA, as part of the permitting, downstream emissions may need to be considered. So I think what we see here is that though the ICJAO doesn't contain direct obligations of private entities, there are indirect consequences for corporations because the activities concern private entities because they might be subject to regulation. There might be more political momentum for increased regulation when it comes to corporate entities, because otherwise states risk committing an internationally wrongful act, which again can then lead, for example, to reparations. But also when it comes to litigation, and we're already seeing the contents of the ICJAO being used in corporate litigation, for example, in a Korean corporate case against the energy company KEPCO. I want to move on to the other important aspect that I see when it comes to this AO, which are climate finance aspects. As I said, in contrast to the Inter-American Court of Human Rights, the ICJ doesn't speak about the necessity to mobilize private capital. But it does say that states have an obligation to cooperate to provide financial assistance. And specifically, they say that developed states must provide financial resources to developing states for mitigation and adaptation, and that obligation is legally binding. They also have a legally binding obligation to communicate information on projected climate finance. They then go on to say that the level of finance, which they don't want to determine in the AEO, has to be determined according to capacities, but also in light of whether the objectives can be met and also the needs of developing states. In terms of the contributor base, the ICJ clarifies that the question of whether a state can be classified as developed or developing is not fixed. So states with rising emissions and higher income levels may face new obligations in regard to providing financial resources. And then in terms of loss and damage, the ICJ stresses that there is a duty of cooperation. Explicitly, they say that states must adopt a cooperative and facilitative approach with respect to loss and damage, but they do stress that the provision on loss and damage does not address issues of liability or compensation. So the claim to reparations, for example, is not excluded because a state might provide resources for the loss and damage fund. And then the last aspect I want to mention is the ICJ's elaborations on the consequences of an internationally wrongful act. They explicitly state that that can lead to compensation, a form of reparation, so that states can demand compensation for the losses they've incurred as the result of an internationally wrongful act. And yeah, that could correspond to the damage suffered by an injured state. So what we're seeing is that this ICJAO does provide many useful arguments to push climate finance, especially for the upcoming COP, but we're also seeing a few abstract terms that need to be made more concrete, whether that is through the upcoming resolution by Vanuatu or further litigation, or yeah, potentially also states that step forward and provide a best practice example of how they're implementing what the ICJAO is saying. Thanks so much.
Thank you, Masha. Thanks a lot. In case you have any questions, please feel free to put those questions in the chat, and we can, of course, take some time to answer those. So we will now turn to human rights and what the advisory opinion says on human rights. I will cover this section myself. I think it's important to say that the findings of the International Court of Justice on human rights are not in themselves groundbreaking. Just like Masha said about the Inter-American Court of Justice on human rights, here again on human rights, the International Court of Justice goes less far than the Inter-American Court. But still, I think it's quite interesting because what the International Court of Justice does here is really giving some weight to the many findings that have been done by UN human rights institutions over the years on the links between climate change and human rights and the impacts of climate change on human rights. I see there's a question in the chat. I'll take it right after my presentation, if that's all right. So what the court does is that first, it says that climate change, of course, has many impacts on human rights via like sea level rise, drought, desertification, natural disasters, etc., which again is something which was quite clear from many UN human rights bodies, but which now really has a strong legal force. So this is important. And another very important thing is that the court says that the protection of the environment is really a precondition for the enjoyment of human rights. And in the same vein, the court says that the right to a clean, healthy, and sustainable environment is inherent to the enjoyment of other human rights. And I think here it's interesting to link this with an ongoing campaign currently happening at European level, because the right to a clean, healthy, and sustainable environment is currently not protected by the European Court of Human Rights, for example. And so there's a strong campaign going on, and I put the link to the website of that campaign here, to adopt an additional protocol to guarantee these rights before the European Court of Human Rights. And so I think here these quite strong statements from the International Court of Justice can really be used to support the policy asks of this campaign, and to put a bit of pressure on the different member states to adopt such a protocol or another legal instrument recognizing this right also at European level. Finally, what I also want to say here is that the human rights law must really inform states' obligation under the climate change treaties and vice versa. So this means that one cannot be taken in silo of the other, and there are really like intertwinements between the two corpuses of international law. So I think this is an important finding as well. So I think we can take a bit of time to respond to questions in the chat now. There's one from Lara, which is what has been the response of the fossil fuel sector, the financial sector, and major emitters to the AO? Quite a broad question, but maybe Masha, you want to tackle it?
Yeah, sure. Thanks for the question. Really interesting. I mean, I can't speak for the response of fossil fuel companies. What I've heard so far is that some companies or also corporate law firms feel quite concerned about a potential wave of litigation or wave of regulation. So that's something they're publicly saying. There is this sense of the ICJAO and other rulings by courts, including the ruling on the RWE case, kind of creating more chaos and legal uncertainty in terms of what can they do, what can't they do. So yeah, I think there is some level of concern, and on the other hand, there hasn't, as far as I've perceived, been a huge corporate response because yeah, many corporations just don't feel directly addressed. And I guess they're right in the sense that the ICJ kind of directly addresses states here and not necessarily corporations. So I think the ripple effects directly for corporations will only play out in the next years. And I think then potentially we'll face harsher responses from that end. Generally, there seems to be a concern of different regulatory approaches in different countries, especially for multinational companies. But yeah, I think I would say the ICJAO offers some clarity in terms of the necessity to regulate private entities. So it will depend very much on the state's responses to as to yeah, how fossil fuel companies will react. And then I saw another question about the majority state-owned fossil fuel companies. So as far as I could see it in the ICJAO, the court basically speaks of the necessity to regulate the conduct of public and private operators. So it doesn't sound like the emissions of public entities would be directly attributable to a state either, but also that they would have a duty to regulate also that public entity. And in terms of, there was one more question on loss and damage. Yeah, I mean, I think what we have to see here is that the ICJ emphasizes the duty to cooperate when it comes to loss and damage. and it doesn't explicitly say there's a duty to pay. And the question is, how do you understand the duty to cooperate? What is a cooperative approach? I think it's another one of those vague terms that need to be kind of filled with life. And in our view, we would understand it as an obligation to provide adequate finance when it comes to loss and damage, but states and others might choose to interpret that in a different way. And I think, yeah, in the end, there's a bit of legal uncertainty as to how exactly that is to be understood. But I think the court kind of tries to walk or do this balancing act between not framing it as a liability issue and thus not excluding basically reparations or compensations as a legal consequence. So I think it kind of tries to balance that out and then also work with the wording in the Paris Agreement, which is more focused on a cooperative approach.
Thanks a lot, Masha. I see a question from Debbie on how basically parties are taking the AO and whether it can add a push in the negotiations. I think we can tackle this in the interactive part of the webinar. And maybe one last question to you, Masha, and then we can move on, is about the findings of the Inter-American Court of Human Rights on company responsibilities, and whether, if you know that there are any reactions so far in America on this, its potential at the COP30, and whether it will be addressed together with the ICJAO. If you have maybe a quick take on this one.
I mean, I work very much in a European context. So from what I've been registering, I just recently attended a conference with lawyers from the US. The AO by the Inter-American Court of Human Rights hasn't actually received as much attention. And so I think we as civil society organizations really have to work to also put that AO in center stage. And I mean, that's something that at least we as German Watch try to do. We have a briefing where we kind of break down the ICJAO, but also the Inter-American Court AO and really stress those findings. But yeah, as far as I know, there hasn't been a huge reaction in the American context, as far as I can see. But if there are any insights in this round, I'd be interested to hear it. I think it would be great if courts around the world actually pick up what the Inter-American Court has said as well. But it's also quite apparent that in many regards, their statements are more ambitious than those of the ICJ.
Thanks a lot, Masha. I would suggest that we move on to tackle the last but not least of aspects that we want to cover from the AO, which is the nature-climate nexus. And I would invite Sophia Gessi from WWF European Policy Office to step in. Sophia.
Thank you, Roman. Thank you for the previous speaker that have already highlighted many important points of the ICJ advisory opinion. So not to keep these slides too long, we wanted to focus a little bit on the climate nexus, nature climate nexus, because this is what WWF has specifically focused in its submission to the ICJ to take a little bit of a, let's say, diverse perspective on this opinion. Of course, as you would have seen from the previous presentation, the nature aspect is not the most dominant in the advisory opinion, but nonetheless is there, and we do, as WWF, see it as a big victory that the recognition of the nature-climate nexus is found in the advisory opinion. So just to highlight a few elements that can be helpful in COP negotiations to make sure that the nature aspect is there, but also beyond that in current European legislation and negotiations that are taking place, as for example, to the future planned revision of the LULUCF regulation. What we see from the ICJ is that there is a strong recognition that nature plays a vital role in the climate system. So there is quite some effort put on the Article 4 of the UNFCCC, where states are legally required to protect and enhance carbon sink and reservoir. So maybe as something that wasn't necessarily mentioned before is that we don't see the ICJ expressing new principles. Like it's just a reaffirmation and reinterpretation of what is already there in the law. But this is how it's actually helpful for us to use it. So repeating Article 4 and the protection of enhancing carbon sinks is not new, but the stress and the focus that the ICJ uses in its advisory opinion, that's what is helpful for us, the clarification on how to use these legal norms. Something that we were very happy to see is that the court also explicitly mentioned that there is no lex specialis across the different legislation that have been put forward. This is something that you have seen and heard previous speaker also mention in relation for example, to the fact that human rights legislation is fully applicable, but also other climate change treaties. And this is because some states have come to the oral hearing proceedings trying to argue that actually only the Paris Agreement or only climate change treaties are relevant to legal obligation of states and consequences. And the court was very strong in saying, actually, this is not the case. There is quite a lot of legislation that are fully applicable and that are considered relevant legislation to lay down obligation for states. And this includes biodiversity convention and treaties such as the CBD, Desertification Convention, and the UNCLOS treaty. And there, what is also quite important for us to mention is that the court clarifies also that this is not an exhaustive list. So there is even more biodiversity and other environmental treaties convention that are considered relevant law to climate states obligation and legal consequences on climate change. So indeed, in relation to human rights, the court recognizes that the right to a healthy environment extends to nature. So it's not just climate that we're talking about, and that states have a continuous duty to enhance and preserve and improve the absorption capacity of reservoir and carbon sinks. And this wording is particularly helpful for the current legislation debates that we're having in Europe regarding the LULUCF legislation. And possibly this is something that we need to use more to remind our European politicians that this is actually a legal obligation and they need to comply. If we can go to the next slide. Thank you. Also very important and not at all something that we were necessarily expecting is the fact that the court fully upholds the findings of the advisory opinion that was delivered the early year by the International Tribunal of the Law of the Sea. So this was also a very important advisory opinion that had very relevant findings, such as the reaffirmation that states have an obligation to protect and preserve marine environment, and that greenhouse gas emissions actually are to be considered pollution in the marine environment in the definition of the UNCLOS. So the ICJ was really not required to completely follow what the ICLOS did, but they did so by recognizing its authoritative role insofar marine environment protection is referred, and fully upheld everything that was already established by the ICLOS, the International Tribunal of the Law of the Sea. In relation to climate adaptation, the court really stressed that adaptation measures are an obligation of states to protect both people and ecosystems, and that ecosystem restoration can operate both as mitigation and adaptation measures. That's also very helpful in relation to the fact that, of course, there are those obligations and how they need to be put into place. The court gives examples such as by bringing forward the possibility to do more ecosystem protection and restoration. And lastly, but not the least, something that was also quite welcome from our side was that in relation to the legal consequences, so as we discussed, there's a lot of legal obligations that have been enlisted by all the speakers in relation to nature as well. And there are some legal consequences for the breach of this obligation. The court doesn't necessarily go into much details on what those legal consequences need to be, because it's something that needs to be addressed in concreto. So depending really on the factual details of the case, but it gives some example, and very helpful examples for restitution is, for example, the restoration of ecosystems and biodiversity. So this is just to say that while nature is not the most prominent finding of the advisory opinion, we see some very helpful wording that should be used and upheld in current negotiations at different levels that we see. Thank you. And I think now I give the floor to either Henry or Nicole for the next steps.
Yes, thank you, Sophia. And Henry, please feel free to jump in. I think as Shirley mentioned in the chat, and I think some of the speakers mentioned as well, there is a UN General Assembly resolution by Vanuatu, and the idea was that to build political power and momentum endorsing all three advisory opinions, and broad country support will be needed on this, and we'll clarify later on how CSOs can support. And there's also the parliamentary question that Henry mentioned earlier on, that can be addressed to our parliamentarians, and also letters to ministries, the Climate Change Commission, Human Rights, and the environment. This is also very helpful. In the past, for the AO, we've done lots of letter campaigns to ministries and ministers and different institutions of the government. So that's part of why it has very successful in terms of lobbying with governments, because with the young people, we really encouraged them, and we had template letters for people to use, for young people to use to write to their governments. And also for the lead up to COP, we're knee deep in terms of meetings, arranging meetings with UNFCCC delegations to help integrate the findings, because what we came to realize is that even for negotiators, there's a need to build capacity. Not much of these, a lot would also need information on how to actually use these AOs, not just the ICJ, but as Masha mentioned earlier on, the one from the Jamaican one is also really helpful, but to how to actually use this and integrate this into the different negotiation streams is very much critical. And together with partners, we're also developing a negotiators tools. It's not yet ready to be disseminated for the public as of now, but we're trying to publish one hopefully before COP. And then also NDC advocacy, as Shirley mentioned later on, the ICJAO was quite strong on this one. So that's part of the, as part of our next steps and advocacy. Also, as a possible way, implementation pathway, perhaps incorporation of these AOs into law and policy curricula. We have partnerships with universities and building like a green legal clinic worldwide to really build capacity on how to use these AOs. And also webinars like this ones, like CSO Unpacking of the ICJAO, and explore synergies with the ITLOS and the Inter-American Court, and potentially the African AO as well. So on the next slide, perhaps the others could also share more about some ideas on implementation pathways. But for us, we're trying to establish or build a landing page for the implementation work stream. And we're trying to develop an implementation toolkit for COP. We're hoping to publish the negotiators tool, but the litigators tool might come later on. But also we are preparing thematic briefs focus on just transition, mitigation, adaptation, loss and damage finance, human rights, so that our CSO partners could use these briefs specific to the agenda or the topics that they are working on, so that they'll also find useful. And lastly, I think I didn't have time to, the link I provided on the slide is not the updated one. So because this is unprecedented, so what we're trying to do is really explore how these AOs can be used and implemented. It's already being implemented as of now. So if you have any ideas of how or heard of how this has been used or referenced, we would really appreciate it, because if you submit, click on the submission forms to give us an idea how the AO is being used already on the ground. And in order to build and develop a more clear strategy and how this can be used way forward. Yeah, that's it on my end. Henry, if you'd like to add anything to that.
Thank you. I think you've done a great job already, and I think we will also try to attach some relevant materials to the follow-up email to this webinar. Thanks. Back to you, Romain.
Yes, thank you both. I think it was yeah, perfect. I think to highlight the next steps. I think we can now move on to the more interactive part of the webinar, where we want to hear from you. And to introduce this, I would hand the floor over to Sigrid from Global Focus.
Thanks a lot, Romain. And I think there were some additional slides, but let's just skip them, and I'll try and do the introduction without them, unless it's an easy fix. Hi, everybody. So now we've heard a lot about the ICJ advisory opinion. For some of you, it may have been the first time you've heard about it. For some of us, we've had several rounds of introduction and work on this, but as it stands, the ICJ advisory opinion is still a very comprehensive and complex legal document. And just to sort of change that narrative a bit, is to see it also as a 140-page invitation for policymaking, litigation, and community organizing, which is what we do best as CSOs or NGOs. So we've already heard a bit about how the ICJ advisory opinion is being used in practice, and we've also heard about the different themes that it covers. And in just a few minutes, we'll give you some time to reflect upon how your organization or community or constituency specifically could make use of the advisory opinion to just start a process of reflection to find out where do you fit into this puzzle. And what we're looking for is not necessarily new ways of spearheading efforts. That's one way of working with the ICJ advisory opinion, but just as much to find out how could you support or contribute to the broader efforts that are already going on to ensure a maximum policy impact of the advisory opinion on European climate policy and beyond. And just to revisit, and that's the slide we're looking at now, just to revisit some of the building blocks when we think about strategy for the ICJ advisory opinion. As I said, we've been through now some of the main thematic issues of the advisory opinion. There are many more, but we've heard about mitigation, fossil fuel and private sector regulation, climate finance, adaptation and loss and damage, human rights, gender and indigenous people's rights, the nature-climate nexus, just transition, and we could continue the list. This shows the scope of some of the scope of the advisory opinion, and also how much stuff there is to unpack still, which Nicole also explained to us just before. Another important building block are the implementation pathways that Nicole also lined up, but just to revisit some of them, the UN General Assembly is one level of action, the UNFCCC, obviously now we're also talking closing up to COP in 2 weeks, the NDCs, and all of our national governments and parliaments are also advocacy targets in this, which could call for more specific strategies. And in order to start thinking in this way, one final building block is also to be aware of the context we're in. So whether we work on a national, local, European, global level, we need to understand, of course, how this discussion is moving forward. And if we just take the next slide. this is a very brief overall context analysis of where the European Union is at this point towards COP. And I thought that this would be a good basis for just thinking, or like have a specific starting point for thinking about actions. And when you get the slides, you can see the details. But I just wanted to mention that we know now that the European Union has, as part of its mandate at COP30, the advisory opinion in 2 references in its council conclusions, which is its mandate for COP. It's two paragraphs. One of them reaffirms the human rights obligations that are also mentioned in the ICJAO, and the centrality of the right to a sustainable environment. And the other one is a more broad welcoming of the advisory opinion, which underlines the importance of the Paris Agreement. And this is something to think about in terms of political strategy, that on the one hand, it's really positive that the European Union is already very specific in its COP mandate on this, but this also already gives us a signal on where the European Union might be moving, that on the one hand, they're reaffirming parts of the advisory opinion, which are very specific, but on the other hand, there's also some cherry picking going on here in terms of not saying there's a lot of obligations outside of the Paris Agreement, for example, which is one of the key things about the ICJ advisory opinion, that it reaffirms a lot of international laws and norms outside of the Paris Agreement. So this is just an input that could be unpacked even more, but just an example of how we should, of course, also be thinking about the specific advocacy targets or targets in general for our strategies, and how this is also a moving target and a discussion that's ongoing. But I think a lot of this was already covered in the previous presentation, so let's move into the interactive part. And if we just look at the next slide, we have 2 questions for you. So we would like you to do some reflection first in silence. You have 3 minutes to just think about these 2 questions and find out, when you look at it from your own organizational perspective or community perspective, what would be your mission for COP30 and beyond with regards to the ICJ advisory opinion? If you were to formulate one mission for what you would be doing, what would that be? And the second question is, what information or resources or connections would you need in order to achieve this mission? So what would it take for you to move into this arena of policymaking or litigation or community engagement on the ICJAO? What do you need that you don't have right now? So let's start the 3 minutes, and you're very welcome to also post your ideas in the chat, and we'll look at that as well. But just 3 minutes of reflection, and we'll return to hear some ideas, or questions are also welcome. So here we go. So I think we're almost there. And I would just welcome you to raise your hand if you want to share ideas or questions, which are also welcome.
We have a hand from Pedro. Pedro?
Hello. I think, and it seems to have been have been getting some good results. Is as ONGs we should probably make legal action against the states themselves that. Especially those that say this is a good thing, but then don't want to follow up on it. And especially against oil companies. We need to do so. We need to take actual legal action, and there's a precedent for that, and that's been a good part of what's been causing them to move forward on this. In my opinion, of course, I'm not 100% sure on that on facts, on the fact perspective. And for that, one of the major things I think one of the major problems we've been having in Quercus has been the lack of legal representation and legal support. Maybe that's the path forward so far, because the legal part, the legality part, the advocacy part, is boring. But it's very, very needed at this point, and this is my opinion.
Maybe just to comment on that. Thanks for that remark. Yeah, I just want to stress that the obligations are defined as erga omnes, so that means they basically everyone can sue everyone. All states can actually, for instance, particularly claim, for example, cessation. So if you're demanding compensation, obviously you have to be an injured state. But in terms of simply bringing an internationally wrongful act to the court, all states would be able to do that. So that's just an interesting component of potential litigation.
That's a very good point. Thank you.
Shirley, do you want to step in?
Sure, just kind of on the question on what would be the advice for the EU going into COP30. It can come in probably obviously, but I think it's a really important point that the EU has not submitted an NDC. And there is so many discussions that are making this very difficult around the 2040 target and the conditions around it. So I think that's something which is really important that the EU engages on its member states with and has a consensus, as well as does make sure it comes to COP with an NDC, knowing that that puts them at a lot of risk given what the ICJ advisory opinion has asked them to do. I was going to say something else on that. Yeah, so I think what I was going to say is that I feel something that I have been saying this whole year, and I think is recognized, I think maybe across the diplomacy world, is that the EU was seen and is seen as the pacemaker on ambition. So I would say in some ways they're already putting themselves in a very difficult position because they've come very late when we know that some parties have been looking to the EU to set the pace and to give a bit of trust in the ambition cycle. So there could be a potential argument that certainly would not reflect bad on them, that ambition across the board, so this collective ambition towards 1.5 has suffered because the EU has been so poor in meeting its obligations under the Paris Agreement. So there's a couple of elements I think that they need to keep in mind there. Thanks.
Thanks a lot, Shirley. Sigurd.
Yes, thank you, Romain. My name is Sigurd. I'm here as Denmark's chief delegate to the UN for Climate and Environment. I was so lucky to be able to talk to the commissioner about this yesterday in a youth dialogue some of the youth organizations had with him. And both talking to him and Dimitris, the current head of delegation for the EU, it seems like the way they want to go about around this is like, oh yeah, we welcome it. Some things are good in the advisory opinion. Some things like we like mentioning the 1.5 goal, mentioning that developing countries is not a set framework. And then there are things that we don't necessarily like. And then the argument becomes that they don't want to highlight specific articles within it. And I guess if they succeed in staying to any other country trying to highlight some of the other parts that the EU doesn't like, and then they can end up in a deadlock if they say then we want the thing about developing countries in there, and then it'll just end up being at the lowest nominator. So I think I can see Peter's point about like litigation being an option here, as it's worked in other cases. But I think as we're going to COP in a few weeks, I think there's a high potential for us to get it into some text. Of course, if we succeed in having some kind of cover decision, I know the Brazilians are not happy with the term, but something else that have the same impact, the non-cover decision, that could be a place. I don't know. There may be other ideas on where it could work and which elements could be mentioned for it to to be balanced. I think mentioning developing will be a red line for China, Brazil, Saudi Arabia, others that could shift over time. But is there like anything, like not saying that directly, but coming closer to that could be a balanced outcome? I don't know. But I think we as civil society would have an interest in as much of that advisory opinion being reflected in it as possible. That would be my contribution. And regarding the NDC, I think the EU negotiators, they are critically aware how much political capital they have lost due to the NDC being so delayed. But it also seemed like everyone is determined to deliver it before COP at the next meeting. It has seemed like this before, so it can change, but also countries that have been dragging the process out earlier, I've talked to, and they seem like they're committed to deliver before the COP and still base it on the 2040 target, so it doesn't get decoupled. So yeah, I hope they'll succeed in that.
Thanks a lot, Sigurd. Maybe one clarification question, because I didn't get it. Whom or which commissioner did you meet yesterday?
Commissioner Hoekstra.
Hoekstra. Okay,
Climate.
cool.
Yes.
Okay, good to know. Masha, you want to react?
No, I wanted to raise a different point, which is that I think we as civil society need to be able to somehow handle the question of how do we deal with particularly NDCs in light of the fact that there are countries like Germany, for example, that have already used their 1.5 degrees budget. So I think that's a tricky one. And the way I also read the section on the climate finance, because it does say that climate finance, the level of financial resources can be determined according to what is necessary for the targets to be met. So that might imply that for those countries, it's necessary to provide even more financial resources to ensure that other countries kind of overachieve when it comes to their NDCs. But I think it would be really important to address that, because there, in a way, when the 1.5 degree budget is depleted, there's kind of this sense of like, oh yeah, it's not realistic anyway, so we don't have to do anything. But I mean, the contrary is the case. Mitigation efforts have to be even more ambitious. But I think that's a bit of a tricky narrative to work with, and yeah, has been really tricky in the German context for sure.
Yeah, thanks a lot, Masha. I think it's important when meeting policymakers that raise the 2-degree objective of the Paris Agreement, to really keep reminding them that no, it's 1.5, the benchmark against which climate policies must be assessed, and even more since the adoption of the advisory opinion. So I think this is something we can and we should really continue doing. Do we have any further reflections? Question? Yes, Sigrid, please.
I have a question for those of you who are unpacking the advisory opinion. I think one or more of you also mentioned in your presentations that there are several places in the advisory opinion where it's mentioned that this would need a concrete assessment per country, like what are the obligations specifically, what's the legal situation in terms of breaches of international law and international wrongful acts and so on. So the term in concreto, or like concrete assessments, is this something that's also necessary for us as NGOs to engage in? Is this a way of pushing for higher ambitions, to say each country needs to make their own assessment up against the ICJ advisory opinion, or how do you view it as a strategy?
I would say yes, for sure, because I mean, court procedures are just very lengthy and complicated, and we want many states, we want many also corporate entities to act now. And I think in a way, one could also say there's also a unique opportunity for states now to kind of set a certain standard as to how the ICJAO could be implemented, because otherwise courts will then define what these abstract terms mean. So they could really, I mean, there's a leadership opportunity here to say, okay, this is how we understand it, and we're actually actively trying to abide by our international obligations. And it also creates legal certainty for them and potentially, companies within their jurisdiction. So maybe that's an argument that would work when speaking to policymakers on a national level.
Yeah, I think this is interesting, right? How to keep the advisory opinion alive within all different jurisdictions, and how to make sure member states take them into account. Yeah, an interesting idea to explore, I think. Yes, Sophia?
I guess I was wondering for those NGOs that are more, let's say, involved on the legal side, more like that they do it all the time as part of their core work, if anyone at this stage is considering launching a legal, like doing basically a litigation case against a state. So not using in corporate action, but against the state. Is that something that people are considering, or is it too early?
Can I? There's at least one organization in Portugal that has been doing that. And they are considering to go into another court case against, I'm not sure, but I believe it's against the Portuguese state. So that has been done and will be continued to be done.
Yeah, I mean, I would say there are numerous cases against states that will actually integrate the ICJAO. So for example, German Watch is supporting a constitutional complaint before the German Constitutional Court, and we will incorporate the findings of the ICJAO into the domestic case. But yeah, I think it will be interesting to see which cases develop on the international level themselves. But yeah, I would say I'm very sure that people are thinking about this, but it just has to be a really well set up, strategically planned intervention, because you don't get too many opportunities to do these types of interventions. So I think it will take time and finding funding and lining up the legal arguments and so on and so forth. Also integrating of how courts maybe nationally are interpreting the ICJAO. but I'm sure that, yeah, it's kind of a question of time because, I mean, hopefully negotiators and policymakers will hear the wake-up call now for COP30, but if they don't, I mean, I think it's clear that corporate, but also, yeah, government framework litigation will continue, and we'll be seeing a case on the international level as well.
Yes, Jolene?
Thanks. Thank you for all this. I'm completely new to all this. This was very clear, and I will look at the webinar again. I had many thoughts. One of them was, is there also somebody thinking of how to explain the moral line of the legal, what is it, the opinion, to the public, and I really like the legal line of thinking and what can we do to force countries to stick to the promises, but I'm both wondering what is the penalty if no one does it on a world scale, and how can we take this moral line, which I read at the ethics, to the broader public so they understand, because like in the Netherlands and maybe in many more countries, it seems that some parties want to withdraw from any international agreements. So what does it mean if we go and make it more in legal terms when the public says, let's get rid of the judges? These thoughts occur to me. Well, I really value and find this very important. Maybe somebody can respond to that. Thank you.
Thank you for your question. Sophia, you want to give it a go?
Yeah. No, very important question. I think what comes to mind, I think you had like twofold part to the question, but one thing that I wanted to respond is that so it does, like what the court says that is really important is that it doesn't really matter if you are or not part of an international agreement at this stage. And it's kind of blinking to the US that has left the Paris Agreement, right? Because of the customary international law that applies, they are still bound to several of these obligations. So it doesn't matter if Italy, for example, tomorrow were to say, actually, you know what, I don't want to be part of the Paris Agreement anymore, they would still be bound. So yeah, this is what I wanted to share. That's actually quite helpful from the ICJ that have said something like that.
I can just very quickly supplement. I mean, that was exactly what I was going to say, but just to bring it slightly forward, I think you're right. There is a lot of discussion on whether these agreements are working and whether countries are thinking about whether they want to be part of it or not, which is a bit concerning. But I think building on what Sophia said, this is really sort of making a very clear statement that they feel like the Paris Agreement is a really important benchmark. So, you know, it gives countries this important conundrum. Do you want to stay within the Paris Agreement and influence how it goes, or do you want to leave and not influence but still have obligations to meet those, meet what comes out of it? So I think it helps sort of push forward the Paris Agreement as a really important mechanism, and could be interesting to see if that affects any of the on the kind of thoughts or discussions around that. Thanks.
Masha, please come forward to take the final word because we are over time now.
Thanks for raising that point. I think like in the professional context, maybe even towards policymakers, it's really important to explain what the ICJAO means, but I think you're getting to an important point, which is kind of winning over the hearts and minds of people. So I think we also have to speak about, you know, why do we even have the Paris Agreement? What's actually behind that? And I mean, fundamentally, it is about having a thriving planet, having a good life, right? It's about something tangible. And I think also we as civil society actors need to make clear why this is important, not only using, you know, technical language or legal language, but actually, I mean, there's something very tangible and very valuable that stands behind these legal principles, the reason why these legal principles exist. And I think it's important to not take the easy way and say it has to be done because the court said so. That's not where we stop, but actually explain why this is important. Also, why the work of NGOs, of civil society actors, is important, because we're not pushing our own organization's interest. We stand for something bigger. So yeah, I think that's really important, because yeah, otherwise people get lost in the complexity, and I think it'll be more difficult to mobilize. So yeah, thanks for raising that.
Okay. Thanks a lot. I think we need to stop now. But I wanted to, well, thank really all the speakers, but also all of you who attended this call. As I said several times, we will follow up with some handy materials, but also with a recording. In case you are not subscribed to Can Europe mailing lists, you can send me an email. I just put my contact in the chat so that I can also send you the relevant information. Yeah, there is still plenty of things to say and to do about the advisor opinion, but I think today was already very helpful in that regard. Let's keep in touch for whatever's next. Feel free to reach out to any of the speakers in case you would like to explore further some of the points. And yeah, I wish you all a very nice afternoon.
Thank you.
Thank you all. Bye.
Thanks. Bye, everyone.
Thank you very much.
Bye.
Good day.